Well, it's another one of those some guys never learn days here on my channel. Hi, Tony DeWitt, Missouri appellate attorney, guy who likes to make the law make sense on YouTube. I don't know that we can make sense out of this, but we're going to try. We're going to talk about two public corruption cases today. One of them in the news and one of them coming out of the 7th U.S. Circuit Court of Appeals up in Chicago. They're just really kind of disgusting cases. Now, the first case we'll talk about is Luis Arroyo, who is a former House member in the Illinois legislature, and we're going to talk a little bit about his conviction. Let's take a look at what the 7th Circuit had to say in his case. The 7th Circuit Court of Appeals, which is the Court of Appeals that sits above Illinois. So this case was argued in April of this year and decided in July of this year. So let's get right to the point here. Luis Arroyo served in the Illinois House of Representatives from 2006 to 2019. While in office, he managed a lobbying firm. From November 2018 to October 2019, his firm received $32,500 in checks from James Weiss's sweepstakes gaming company. Arroyo admitted that he received payments from Weiss's company in exchange for his official support for the sweepstakes industry in the General Assembly. Now, prior to 2018, he never had any interest in sweepstakes, but afterwards, he started supporting it. And he never revealed his financial arrangement with Weiss. So in August 2019, after failing to pass sweepstakes legislation, Arroyo and Weiss sought to enlist a state senator in their scheme. In a meeting with the senator, Arroyo admitted to receiving payments from Weiss for advancing sweepstakes gaming interests in the General Assembly. And he asked the senator to sponsor a gaming bill in the Senate and promised the senator would be paid for doing it. Unbeknownst to Arroyo or Weiss, the senator was working with the government and wearing a wire. An important note for all of you public officials out there who might be tempted to try to corrupt your other public officials. Not everybody is corrupt, and not everybody is corruptible. Kudos to the state senator who blew the whistle here. 3 weeks later, Arroyo gave the senator a $2,500 check and says you're going to get one every month. Thereafter, he was charged with bribery. He was charged 1 count of bribery, 3 counts of wire fraud, and 1 count of mail fraud. In November of 2021, Arroyo pleaded guilty to 1 count of wire fraud. So, did you happen to notice what went on there? Because I think it's important. They hit him with all these different charges, which would increase his range of punishment probably until he was dead. Probably be effectively a life sentence for him. And they allowed him to plead guilty to 1 charge of mail fraud. That does not sound rational to me. I'm sorry. If he did the crimes, he ought to do the time appropriate to the crimes that he did. As often happens after someone has been convicted of a serious felony, the case proceeded to sentencing, where the district judge emphasized the seriousness of Arroyo's offense and said he needed to deter other public officials who might be tempted to sell out the public like Arroyo did. And he phrased this in economic terms. He said, from a supply and demand perspective, the length of the sentence matters. The lower the cost, in other words, the lower the sentence, the more public corruption you're going to get. I couldn't agree more. The judge emphasized the need to make sure that the costs of public corruption are high enough to deter other people from engaging in public corruption. After weighing the other sentencing factors under the statute, the judge imposed a sentence of 57 months, the top end of Arroyo's sentencing guidelines range. And the judge also ordered Arroyo to forfeit $32,500, concluding that all of the payments Arroyo's lobbying firm received from Weiss were bribes. Arroyo appeals, challenging his sentence on procedural grounds and the forfeiture amount. Arroyo argues the district judge's reliance on general deterrence amounted to procedural error. We question whether Arroyo's challenge is, in fact, procedural and subject to de novo review, but the answer is the same under any set of circumstances. Sentencing judges must consider, among other things, the need for a sentence to afford adequate deterrence to criminal conduct. By including general deterrence as a required consideration, Congress embraced the idea that criminal sentences influence behavior in society. Arroyo argues the judge procedurally erred because the record lacked empirical evidence showing that the public officials consider sentences to engage in cost-benefit analysis when it comes to corruption. Arroyo says the judge's analysis was purely speculative and unreliable. The judge, Arroyo further argues, relied almost exclusively on general deterrence while ignoring mitigating facts like his age and lack of criminal history. In essence, what he is arguing here is, look, it didn't deter me, so why would it ever deter anybody else? I think that's a really dumb argument. I mean, it's creative, but it's really dumb. General deterrence is, after all, an economic theory of punishments. Where the profit to be made from violating a law is higher, the penalty needs to be correspondingly higher to achieve the same amount of deterrence. And the court notes that bribery is a premeditated crime. Those tempted to sell out the public have plenty of time to weigh the risks and rewards before doing so. The judge did not err by reasonably presuming that public officials consider the criminal consequences, and the longer sentence for Arroyo was necessary to deter corruption at the margins. So then he also said the judge erred by focusing exclusively on general deterrence and ignored mitigating factors. The judge did not ignore mitigating factors. The judge noted that Arroyo's age would make incarceration difficult and found his lack of criminal history mitigating. And the judge highlighted Arroyo's challenging upbringing, years of public service before his corruption, devotion to his family, and the dozens of letters submitted supporting Arroyo. In short, the judge addressed all of Arroyo's arguments in mitigation, committing no procedural error. Relatedly, Arroyo argues the judge erred by deeming his allocution aggravating after promising him that his statement wouldn't be held against him. Arroyo points to the following excerpt from the sentencing transcript. I've considered your statement, your allocution. You didn't have to address the court. You did. I considered that. So those are the aggravating factors that I've seen so far. When read in isolation, one might come away with the misleading impression that the judge found Arroyo's allocution aggravating. But when placed in context, it becomes clear the judge did no such thing. In the preceding pages, the judge emphasized the seriousness of the offense. The judge then paused to note that he considered Arroyo's allocution before referring back to these aggravating factors. Despite the abrupt transition, nothing in the transcript suggests the judge concluded that Arroyo's statement was itself aggravating. Finally, we turn to forfeiture. We'll reverse it only if our review leaves us with a definite and firm conviction that the district court made a mistake. Arroyo hasn't met that bar, and as a result, it is affirmed. So I'm not sure you can make sense out of that. Why a guy would operate a lobbying business at the same time he's in the legislature, that's a direct conflict of interest, and I don't know why he was allowed to do that. But the whole idea of taking bribes to pass this gaming system, when Illinois already has plenty of gambling everywhere you look, they have lottery, they have casinos, all that stuff. It's just clear that people who run gambling operations just enjoy picking the pockets of people who are too stupid to do math. But that's another story. I thought perhaps to explain this, I might go to a subject matter expert, somebody who's been here on the channel before who could probably explain this better than I could. So let's switch over now to Tony Two Toes, who might have some explanation for us here. You want me to explain this guy? This. Whoa. Sorry, I'm listening for a little problem that I got. You want me... hold on one second. Sorry, where was I? Oh, yeah. You want me to explain this clown? Because, you think that I, as a criminal, have an explanation for a guy who's supposed to be serving the public and is instead dipping his hands into the till, lining his own pockets? That's my job. I can't explain that. I should have... There's no way. The guy's horning in on my word. I had to cut him off there. He got a little upset about this guy ripping off the public when ripping off the public really is his job. And he's doing it pretty well, although apparently he was listening to a police radio for some reason. I don't know. Anyway, the whole case doesn't make any sense to me. You would think that this would have been something that would have come to someone's attention well before it got to the point where he was taking $32,000 in bribes. You would have thought that the whole idea of operating a lobbying business at the same time you're in the legislature would have triggered alarm bells somewhere, but apparently in Illinois, it's just the way they do business. So now let's take a look at the rather strange case of Roy McGrath. And to do that, let's take a look at the news report that came out regarding his rather untimely passing. So just a few days ago, they released the autopsy of a guy by the name of Roy McGrath. Now, this is the report from Fox News in the District of Columbia about the event. The fugitive ex-chief of staff for former Maryland Governor Larry Hogan. He's a former political aide who failed to appear for his trial on federal corruption charges. So apparently, after he failed to appear, instead of making an attempt to appear, what he did was he went on the run, and he was located near Knoxville, Tennessee. Another helpful tip for those public servants who decide after corruption and after indictment and after spending money on bail to flee the country. Actually flee the country. Tennessee may look like another country when you've lived your entire life in Maryland. I don't know, but it isn't. It's actually a United State, and they will extradite you from there. I can't imagine why the guy didn't get on a plane and head for Costa Rica or El Salvador, where he might very well have gotten a much warmer reception. So he was, the report says that FBI agents in Baltimore asked if Knoxville agents could arrest McGrath, and they provided a copy of the warrant and a description of McGrath's vehicle and information about McGrath's location. So when the agents got there, they found McGrath's vehicle and attempted to conduct a traffic stop, and McGrath continued to drive until he was boxed in between two other businesses. In case you wondered about the wisdom of running from the cops, it's not a good idea. It always ends like this, with a pit maneuver, and at the end of the day, you wind up going to jail anyway. You got the FBI and they're on your tail, you're probably not going to be able to outrun them because they have helicopters and everything else. But they boxed him in, and at that point in time, the FBI approached and yelled FBI and ordered him to put his hands out the driver's side window, and he said, "No, I have a gun and it's loaded." So this is absolute genius right here. Agents saw McGrath with a handgun raised to his right temple, and the way McGrath held the handgun placed agents within the trajectory of McGrath's gun, causing one agent to believe McGrath posed a threat of imminent death or serious bodily injury, and so he fired his gun, striking McGrath in the left cheek, while at the same time McGrath fired his gun, striking himself in the right temple, and he lingered for a couple of days before he died. Now, he was the chief of staff to former Maryland Governor Larry Hogan. He was indicted in 2021 on accusations that he fraudulently secured a $233,648 severance payment equal to 1 year of salary as the head of Maryland's Environmental Service by falsely telling the agency's board the governor had approved it. He was also accused of fraud and embezzlement related to roughly $170,000 in expenses. Oh, and by the way, in a superseding indictment, he created a fake memo from Hogan that approved his severance, and that got him charges for wire fraud and theft. So basically what happened is they determined that the agents had acted in self-defense. In doing this, he lingered at the hospital for a few hours before he died, and that's one of the reasons why they said that one of the gunshot wounds was self-inflicted and the other was not. Due to the prolonged survival interval after sustaining the wounds and ultimately dying in the hospital, it cannot be determined which gunshot wound killed him, and whether, therefore, the cause of death is basically could not be determined. Gunshot wounds that caused manner of death could not be determined. I was born in the 1950s and grew up in the 1960s, back when people generally had a pretty good feel about the FBI. And when you said something like serious criminal, you thought of people like this: John Dillinger, who robbed banks and was public enemy number one for a long period of time before he made the mistake of going to a movie theater with a woman. Or Babyface Nelson, who also met his end at the end of a FBI firearm. You know, the FBI has tracked down all kinds of people, spies, and you name it. It is absolutely amazing to me that you have someone who is just on trial for taking a bribe, basically, and wire fraud. I mean, the guy would have probably spent 5 years, 6 years in federal prison, but he would have been in a white-collar prison, one of the more moderate prisons where there aren't any real criminals. And as a result of that, he really didn't have that big of a mess in front of him. But instead of doing that, he goes and takes his own life. You know, he insists on, well, I don't know whether it's suicide by cop or suicide by self and cop, but whatever it was, he managed to take his own life. So that's the bad part. The good part is the taxpayers were spared the expense of a trial, and we have one fewer public corrupt official out there working for the state of Maryland. Hard to tell how many others there might be, but I can assure you that in almost every state, maybe in every state, there is at least one public official who's lining his own pockets. That seems to be a real issue with respect to how our government operates, and not one that I am capable of solving other than by voting for people that I hope and pray will do the right thing when the time comes. Well, that's what I have for you today. It's kind of an interesting set of cases. I hope you found it interesting. I hope you found the results in those cases satisfying. I think almost 5 years for wire fraud is a pretty good sentence for Arroyo. And, when you play stupid games, you win stupid prizes as far as McGrath goes. Thanks again for watching. If you have the opportunity today, please take a moment to do something nice for someone. You never know what kind of personal hell someone might be going through. And sometimes just opening the door for them and smiling at them and saying, how's it going today? Sometimes that's all it takes to really help somebody through a rough patch. So have a great day and catch me down here at the beach next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.